McConnell Family Law Group. I'm going to talk to you about private equity considerations in high net worth divorce cases. Are you somebody who's contemplating divorce and your spouse works in private equity and you're aware that they have very complex compensation methodologies and structures? Or do you work in private equity and you want to make sure that the risks associated with your position and occupation are fully considered? So I'm going to talk to you about how those issues play out with respect to private equity. First, I'm going to provide a little bit of background in private equity in general. And if you work in private equity, you may want to skip over this part and skip ahead to where we're just talking about what documents we're going to request and the like. But for those of you that are a spouse and the other spouse, whether it be your husband or wife, works in private equity and you're not as familiar, let me give you a little bit of a background. First of all, with respect to an overview of the structure, as you can imagine, a private equity firm has a number of professionals in it, and there's a hierarchy, just like any other business. There might be the founding managing director, or managing director, and then a vice president, an associate, and an analyst. Some firms have different terminology for the different levels of occupation, but that's how firms are organized. And then some private equity firms are very large, and they may be managing a number of different funds within them. Other funds are smaller, and they may only be doing one fund at a time, or I should say other firms are smaller. Each of the funds, whether it's a firm that has a number of funds or just one fund within a firm, has a makeup to it. It has limited partners. Those are the people that invest large amounts of money that form the capital for the fund. For example, high net worth individuals and family offices or pension funds and the like. That's the source of the capital. Those are the limited partners. Then there's the general partners, and they're usually some, or in some cases all, the professionals that are in the private equity firm are the general partners, or at least some of them are the general partners for this particular fund. The capital contribution also comes from the general partners, although it's often quite a bit less. So general partners may only contribute, for example, about 2% of what the overall capital is going to be, and the limited partners would contribute about 98%. In addition to that, there's the portfolio companies. That is, once the fund raises a bunch of money, the next steps are the professionals and general partners that are making up this fund. They're going to invest in companies. They're going to buy companies, for example, and those are the portfolio companies. At the end of the day, they grow these companies over a period of time, whether it's 2, 3, 5, or even 10 years. They generate profit from these companies, and they ultimately dispose of these companies. In some cases, they take them public, but more often than not, they sell them to some larger entity, for example, a Fortune 500 company. And it's through the growth of these firms, okay, and then the ultimate disposition, that's what generates, hopefully, profit and a lot of money. And that money ultimately is distributed. And you may have heard the term carried interest. It's a term of art that's used frequently. At the end of the day, although it has a specific meaning and specific definitions as to each particular fund and the like, at the end of the day, that's the profit that's going to be distributed ultimately to the general partners. And you may be married to a spouse who's going to participate in receiving some of that carried interest. That's really what we're getting after here. There's a life cycle for each of these funds, typically, for example, about 10 years. And there's different parts, there's the investment period where the capital raise, and the investment period where they're buying companies, investing in companies. And it's not all at once. And so over the course of a couple of years, they might buy 1, 2, 3, 5 companies over the course of a couple, 2, 3, 5 years. And then there's the harvesting period where the profits start coming out and the company's ultimately disposed of. Sometimes, even if the term is 10 years, it might be extended for business decision reasons. At the end of the day, there's basically a J curve, they call it in the industry. So from the beginning, there's a large amount of capital going out in the form of purchasing companies, investing in companies, and then ultimately the profits are growing and the companies are disposed of, and more profit comes into the fund and is ultimately distributed. How is it distributed? The documents are going to govern that. It's a general proposition. The limited partners are going to first get all their capital investment back, okay? If they invested $100 million, they get that $100 million back first, okay? Then there's typically something called a hurdle return, which is often, for example, about 8%. So before any of the other profits are distributed, the limited partners are going to get that hurdle return of 8%. And then the general partners start to participate in whatever the profits are. They're going to catch up, getting their capital back and getting their 8% return. And then the additional profits are going to be split, and that's the carry, okay? And typically those additional profits will be split, typically 80% to limited partners, 20% to the general partners. And that's where the money is, that is property that you're going to be talking about how to distribute that's coming down the road. What if the company underperforms or the fund itself underperforms? Those are all considerations that have to be factored in as well. There's something called a clawback, and that is over the course of the payouts, if some of the general partners started getting some carry, but then the particular company or the fund started underperforming, there's a clawback where they might have to reinvest or back into the fund. And so if you work for the private equity company, you obviously want to be concerned at any type of division that if you're subject to clawbacks, that is fully considered, that risk component to it all. There's a number of documents that we request in these cases. For example, the fund limited partnership agreement, the fund private placement memorandum, the fund audited financial statements, the valuation schedules, the internal schedule of capital calls and carry, copies of investment committee memos, copies of limited partnership communications, internal schedule of capital calls and carry, the date regarding the portfolio companies, the operating and limited partnership agreement and of funds of the general partner, financial data, that is tax returns, internal financials, K1s and the like, as well as the operating limited partnership agreement of the management company. These are all subject to non-disclosure agreements, the terms of which are negotiated, but it's something we've done regularly in these cases, so we're not reinventing the wheel in any one of these particular cases. With respect to valuation, how's it going to be valued? This asset, that is the ownership interest or the potential for future income on these with respect to carried interest. In general, it needs to be valued as of the date of divorce. That's just a principle of law that applies in these cases, and it's just the source of debate with respect to how to come up with the actual valuation. There's some common philosophical objections that we see arise in all these cases. That is, a professional might claim that the carry should be worth whatever we would get if everything was liquidated today, or the general partner agreement has a vesting agreement, and if I'm not currently vested, only the unvested portion should therefore be excluded. It's not possible to know with certainty what carry will get paid out, so therefore it's impossible to give any value to it. And then what should we do about clawbacks? The point of it is, this may be your first divorce with respect to private equity or your spouse's and the like, but it's not the court's. We've dealt with all these issues before, these questions and the like, and the judges are familiar with it, practitioners in this area are familiar with it, and as are the experts that we all customarily rely upon, and I'll talk about in a second. There's different methodologies when we hire an expert. What are they going to do to provide an opinion? There's different methodologies. There's a market approach, there's an option model, an income approach, and the like. The point of it is there's different methodologies, there's also different assumptions, what the discount rate should be, return multiples and the like, and the experts can debate what should be used, and that impacts the ultimate value of this asset to be divided. At the end of the day, you may have an expert that comes to the conclusion that it should be $5 million, and another expert would say it should be $10 million. Okay, if you have to go to trial, the judge is going to credit one expert or the other, or find some reason to credit part of one expert's testimony versus another expert's testimony. Most of the time, we resolve these things through negotiation. I'm talking wave tops here. I'm not an expert on this. And if you're a private equity professional, you can already see the gaps and things that I'm speaking about. I'm just hitting the wave tops, but we always hire an expert in one of these cases. I could name 3 or 5 off the top of my head right now. That if you're a spouse and not working for private equity yourself, we're going to have on your team that does this time and time again. They know exactly what these documents are, what documents they need, and how to do the valuations and the like. And it's been my experience that if I have the private equity professional that I'm representing, that they become comfortable with the expert on the other side. Similarly, if I have the spouse who's not working in the private equity, they're very satisfied that the expert we have is adequately protecting them. And typically the professional on the other side comes to be comfortable with them too, to see that their interests are being covered as well, because they're speaking the same language. The point of it is, I don't claim to be an expert, but you should have an attorney that's familiar with the terminology, has done high net worth cases, has dealt with private equity cases. Now, there's different ways to reach a resolution, whether it's through a court decision or hopefully through compromise. And that is, once we have a value, you could do a buyout. And that is if there's enough assets to be divided. If we agreed after a lot of discussion that the value should be $5 million, that means the other spouse should get $2.5 million. Then how can we provide that from other assets and the like? The benefits to that is there's finality. There's no ongoing entanglement. Of course, you need to agree on what that value is going to be. Another methodology for the division would be on an if, as, and when basis. If there is a payout and when there is, that's when the division would occur. The benefits are that both parties then share with respect to the risk. A precise valuation is not needed because ultimately the private market's going to decide what the value is. But the downside is that creates years of additional entanglement. There's going to have to be accounting true-ups and the like. There has to be an address for future capital calls as well. Again, we're going to hire experts. Everybody's going to have experts. Sometimes if I had a private equity individual as a client, they have their own expertise, and if it proceeds through negotiation, we don't need to hire an expert. If we go to trial, then of course we would, because it's just more beneficial to have a somewhat more objective voice testifying. The goal at the end of the day is a fair resolution that takes into account all the competing factors. Of course, fair is, we always think we're being fair, it's the other side that's unfair, but the point of it is we work through, that's more the right side brain, and we can work through that, and so long as everybody feels like everything's been talked about and considered, we can come to a resolution, whether it's through a valuation that we agree on or a division on an if, as, and when basis. All that being said, I worked for General Mattis once upon a time. You may have heard of him. He was former Secretary of Defense. I worked for him when he was a colonel in the Marine Corps, and I have the scars on my back to prove it. You may have heard that he once said, with respect to Marines, there's no better friend or no worse enemy. That's a battle cry that we keep here at our firm as well. No better friend, no worse enemy. Thank you.